welcome back to our channel Low Point. This is Anisha Babu. In our very first session on Low Point, we covered what is will and how to execute a will. But what happens if a person dies without executing a will? How will his legal heirs inherit his assets and properties? That is what we are going to cover in our next few sessions. We have a Supreme Court of India's advocate on record, Mrs. Priscilla Elizabeth Joseph, to talk on the same. So let's watch.
In our very first session, we had seen what's a will and how it is executed. That session was related to testamentary succession. That is, how inheritance takes place when a person dies leaving behind a will. Today's session is related to intestate succession. That means situations where the person dies without creating a will and how that person's property is transferred to his legal heirs by the applicable laws of intestate succession. Who is a legal heir? Legal heir could be parents of the deceased, siblings of the deceased, spouse of the deceased, children of the deceased. They are generally considered to be the legal heirs. A legal heir can be either a man or a woman. General perception is that inheritance is the practice of transferring property titles and rights to the legal heir of a person upon his death. You will be surprised to know that the legal heirs of a deceased person also inherit his liabilities and debts to the extent of one's share in the inheritance. Suppose you have inherited 2 lakhs and the deceased had a debt of around 5 lakhs. Your maximum liability will only be to the extent of your inherited 2 lakhs only. The remaining outstanding 3 lakhs will not be recovered from your personal savings or personal property. After the death of the owner, the legal heir must register for change of property ownership to their name. This procedure is called mutation and it updates the property owner's name in the government records. After the legal heir has acquired the property, he may choose to reside in it, lend it, or he may even sell it. Laws of intestate succession are different for Hindus, Muslims, and other religions. Now, you may wonder why this is so. This is because when the laws of the land reflect the sentiments of its citizens, then there is greater harmony among different sections of the society. Considering the same, Articles 25 to 28 of the Indian Constitution guarantee religious freedom to Indian citizens and allow religious groups to maintain their own affairs. As such, important events like marriage, divorce, property, inheritance, adoption, maintenance, etc. are governed by the personal laws of citizens based on religious scriptures. However, in a democracy where citizens are equal, one school of thought is that one single law must apply to all citizens irrespective of their religion. Accordingly, the Uniform Civil Code was proposed, but it has so far not been passed by the Indian Parliament. Coming to our personal laws, Hindus are governed by Hindu Succession Act. Hindus include Buddhists, Jains, Sikhs also. Prior to 2005, sons enjoyed rights over the deceased parent's property, whereas daughters could do so only till she was unmarried. However, after an amendment in the year 2005 to Hindu Succession Act, married and unmarried daughters have same rights on their parents' property as their brothers. It's important to note that they are also entitled to equal duties and liabilities as their brothers. Distribution of property after the death of a Muslim is governed by the principles of Shariat Act. The sources of Muslim law are, first of all, Holy Quran, secondly, the practice of the Prophet called the Sunnah, thirdly, the consensus of the learned men of the community called Ijma, fourthly, analogical deduction of what is right and just in accordance with the good principles laid down by Allah called the Qiyam. It's important that you know that by way of a will, a Muslim can write away only up to 1/3 of his property, whereas the remaining 2/3 of the property is covered by intestate succession only. Indian Succession Act applies to Christians, Parsis and those who have inter-religious marriages under Special Marriage Act. Their children too will be governed under the Indian Succession Act. For example, if a Hindu woman marries a Muslim man under Special Marriage Act, their succession will be governed by the Indian Succession Act and not under their personal law. This is provided under Section 21 of the Special Marriage Act by an amendment to Section 21A of Special Marriage Act, wherein if marriage is between two Hindus, then they will be governed by Hindu Succession Act and not under Indian Succession Act. Each of the personal law has so many intricate details to be touched upon that we cannot cover it all in one session. So, I will be dealing with the personal laws in great detail in my upcoming sessions. Thank you.
Thank you for watching. Stay tuned. Till then, take care. Bye-bye.